Hello everyone. We are here because we desire to become a notary public and open a successful practice. However, there are a lot of challenges in our road to success. We learn several ways and techniques to overcome these challenges in our course of study. Further, for the smooth and productive continuation of our profession, we must understand the importance of ethical culture at workplace. In this presentation, New Gen CFO provides an insight of ethics and discipline. This presentation describes the society documents and their expectations, administrative law, ethical standards and systems at workplace, disciplinary actions, procedures, and their ramification. Let's begin by understanding what are ethics. Aristotle defined ethics as people ought to behave to achieve happiness. According to Thomas Aquinas, to live well is to work well, to show a good activity. The words from Kant says that in law a man is guilty when he violates the right of others. In ethics he is guilty if he only thinks of doing so. John Stuart Mill states that I have learned to seek my happiness by limiting my desires rather than in attempting to satisfy them. Different legal philosophers provide different view on ethics. To summarize, ethic is a set of principles and values which governs the conduct of an individual with an emphasis of determining what is right from wrong. Let's hear what Mr. Wainwright defined ethics in a notary practice.
Ethics is really quite an all-encompassing word and thought, and it's really about professionalism. What makes a professional? What makes a professional is belonging to an organization that is self-governing, which of course the Society of Notaries Public is. And how does that make you a professional? And why is there a certain ethical standard that you, as a member, as a notary, want to adhere to? First of all, it's because of legislation. There's legislation that says that you could belong to this organization because it's self-governing, but the organization that has a duty of care to whom? The public of British Columbia. And so together as a group, the notaries, we've agreed that there will be a code of conduct, that we will have certain ethical standards, practice standards, if you will, a number of different standards, audits, that accounting and looking after people's trust monies, that you're going to meet a certain standard for that. That's really what all of those things together is can be maybe summed up in one word: ethics.
There are several ways of identifying the ethical issues. One of the most common ways is rules versus consequences criteria. Rules illustrates that our actions should be guided by general rules or principles, like do not harm, tell the truth, do not steal, respect for persons. The consequences define that we should assess the rightness of an action or decision by the consequences that will likely result. Most commonly, the second approach identifies some values and measures the actions by the extent to which these values are or are not enhanced or progress made towards certain goals, such as a better life for all. However, ethics in the workplace does not adopt such simplistic approach as mentioned before. Business ethics are principles, values, and standards that guide behavior in the world of business. Businesses face more complicated ethical issues than individuals. There are a variety of economic motives and other factors that intrude on workplace ethics. Workplace ethics tend to be far more complex and requires a more practical approach, which will take these economic motives and economic factors into consideration when determining organizational behavior models. Businesses tend to make profits in order to survive, but they owe fiduciary duty to their clients as well. The life of the business is directly related to the profit that business makes. However, if a business earns only profits and ignore ethical issues, the life of the business will be short. Businesses must know to balance the amount of profits with the needs of the society. Many businesses have failed due to financial and legal implications resulting from their poor business ethics. Hence, a healthy balance is required. Ethics at workplace or business ethics is very important. After many incidents involving unethical behavior in business, it has become apparent that there is a need of better understanding of what is considered right or wrong in the world of business. Business ethics are viewed from a religious point of view until 1960, when an anti-business attitude begins to emerge. During 1960, huge ecological problems began to emerge that raised the issue of mismanagement of environmental resources. There is also an emergence of organizations to protect consumer rights. In 1970, business ethics become a field of study and corporates are taught their social responsibilities. Social responsibility is the obligation of business organization to minimize its benefit to all stakeholders with minimal negative social impact. In 1970, business became more concerned about the public image. Now businesses began to realize that they have to deal with the ethical issues in a direct manner, which often meant putting social issues over profits. Many companies emerged as green companies and made social management as an integral model. There were many investors that put social responsibility as prime factor for investing in a company. Currently, the trend is moving away from government control of business ethics towards cultural efforts that made good principles and values a core part of company's culture, with an ethical component known as ethical culture. Moving further, we must know the difference between ethics and professionalism. Ethics refer to the guidelines that state the do's and don'ts in a specific context, whereas professionalism refers to the specific traits that are expected of a professional. Secondly, ethics are usually stated, whereas professionalism is cultivated by the individual personally. Let's dive further in the topic and expand our understanding in other relevant areas.
So a professional really has a high standard of ethical responsibility to their peers, to, in our case, the society that we belong to. A very clever lawyer once told me that ethics is doing the right thing when nobody's looking. And so if I have a message for new notaries going into practice, is keep that in your mind. It's doing the right thing when nobody is looking. And sometimes that's quite hard to do.
The expectations of the society surrounding ethics and discipline are centered around the following three documents: Constitution and Bylaws, Society Rules, and the Principles for Professional and Ethical Conduct, also known as the Code of Conduct. Let's hear what Wayne Braid has to say about the genesis of the Rules and Code of Conduct.
As a professional, you're saying to the public, there's a set of rules that I abide by, that that I subscribe to, that protects you as the public, so that you know that the service that I'm providing, there is some responsibility there for me to make sure that I do it right. I don't think any of us like rules, you know, and it was one of the things that we always struggled with at the society was, because you can have rules about everything. You can have rules about everything. So that's why we came up with the Code of Conduct. And the Code of Conduct really is not a set of rules. It's a guideline there for members when they're faced with situations that may be gray area from the rules, may be certain that something that you're just uncertain of in the rules. And so the Code of Conduct, as I say, is there as a guideline. And it's pretty instructive.
The three society documents are derived from legislation in the form of the Notaries Act and regulations. In this section of the presentation, I will briefly examine parts of the Notaries Act. Section 18 sets out the rights and powers of members. This section of the Act gives notaries their scope of practice. British Columbia has a unique situation that gives notaries the very special privilege to perform some legal services that are usually restricted to lawyers. Section 23 is very important as it relates to the maintenance of books and accounts used to keep track of funds clients pay to notaries in trust. Section 24 provides for the requirement that notaries will be subject to random audits of his or her books and accounts. Failure to maintain proper account records can have serious consequences for a member. Sections 25 through 40 relate to the Discipline Committee and Board of Directors and their disciplinary powers. Section 41 provides the knowledge that all disciplinary decisions can be appealed. And now let's have a look at the Constitution and bylaws. The Constitution consists of 6 points, and next to the Notaries Act, the Constitution is the most important enabling document of the Society, and it confers the authority by which the bylaws, rules, and code of conduct can be enforced. These 6 points of the Constitution set out the purpose of the Society: a mandate to provide, promote, and advance high standards of service, to provide continuing education to members, to examine notary students, set, provide, regulate, and maintain professional and ethical standards for members, supervise and discipline members, and lastly, to undertake any other acts and services as may be necessary to augment the purposes listed above. The bylaws control operation of the Society and activities of the Board of Directors. Bylaws must be submitted to and approved by the Attorney General to be enforceable. The various committees of the Society are outlined in Bylaw 8 as Executive, Audit, Education, Finance and Investments, Membership and Credentials, Board Development, Insurance, Legislation and Bylaws, Practice Inspection, Public Relations and Magazine, Discipline, and Taxation. And now on to the Society rules. Rule 2 sets out requirements for membership and continuing education. Rule 4 holds the requirements surrounding notary trust accounts and bookkeeping. The rules assist the auditor in completing the mandatory annual audit of each member's accounts. Strict compliance is required by each member surrounding trust accounting. Failure to comply will result in disciplinary action. Both of my mentors to date have made a point of stressing how important this concept is for notaries. The big takeaway here is to remember it's not your money. Here are a few points regarding trust accounting from Rule 4. This is just a sampler, as the Society rules have over 6 pages pertaining to trust accounting. You must inform the Society within a month of opening a trust account. You need to instruct the financial institution to pay any interest to the Notary Foundation. You must not deposit over $2,500 unless specific conditions allow you to do so. Each trust transaction that is required to be recorded must be done within a week after the date of transaction. Only the notary or another member can sign trust checks and must be done in person, not with a stamp signature. No funds can be withdrawn from trust accounts before completion of registration. You must immediately report a shortfall over $5,000, and members must cover the missing funds of any amount into the trust account from a general account. Reconciliation must be completed once every month, and errors must be corrected before the next reconciliation period. Rule 5. Control over members' practice in the event of bankruptcy. Rule 6. Claim against the special fund. There's an inquiry process via the Discipline and Insurance Committees. Rule 7. Professional Liability Insurance Program. This is the Errors and Omissions Program, and it's mandatory for all members to participate. Rule 8. Discipline. A complaint is made in writing alleging unprofessional conduct conduct, incompetence, negligence, or fraud. The Secretary will conduct preliminary investigation and then it would be handed off to Discipline Committee. Rule 9. Fines for contravening any provisions of the Act, bylaws, or rules. Rule 10. Undertakings. This is a promise, and it's written or implied, absolute, and irrevocable. An example is the report notaries must make to the Mortgage Discharge Center if after 60 days they have not received notice of the discharge. Rule 11. Professional conduct. This is a very complex set of rules. Every member owes a duty to a client to represent that client competently and with undivided loyalty. The member shall not continue to act if a transaction is beyond the lawful practice of a notary public or outside the competence of the member, or if there is likely to be a conflict of interest. The professional conduct rule covers the notary's duty to clients, conflict of interest, acting for multiple clients, informed consent, unrepresented parties, and restrictions on practice. To really understand these, one must review the Principles of Conduct document, which sets out the principles to be considered in each of these areas. Rules 12 through 18 deal with subjects such as employee supervision, advertising guidelines, appeals, incorporation, document retention, and practice inspection. And now on to the Code of Conduct. This document of the Society of Notaries Public of BC describes a set of guiding principles to assist professionals in solving ethical dilemmas, as we heard Wayne braid earlier. To maintain the profession's present standing, notaries must command the trust and respect of the public. This document doesn't create legal obligations, but is modeled after legal standards created elsewhere. For example, the SRA, which is the Solicitor's Regulation Authority from the United Kingdom Law Society, has a code of conduct that states, ethics will guide a professional to ways of behaving in relation to moral dilemmas that arise in practice. Ethics involve making a commitment to acting with integrity and honesty in accordance with moral principles. Ethics are based on the principles of serving the interests of consumers of legal services. Our code mirrors these principles in many ways. The Notary Code of Conduct is outlined in 13 principles, or general standards of ethical and professional behavior. Number 1, integrity. Fundamental quality for anyone who seeks to practice as a notary. A member who is lacking in this quality will not be able to serve their clients effectively and will take away from the notarial profession. Number 2, avoiding questionable conduct in public or private. Avoid behavior which calls into question a member's professional integrity. Preparation and swearing of documents is the third. Be meticulous in preparation of documents and give care in attesting them. For example, my recent mentor, Christy Martin, had this to say about drafting a statutory declaration. If you think it sounds like overkill, then you have done it correctly. Number 4, competence, quality of service, and relationship to clients. Do not exceed your scope or competence level. Direct clients to those professionals that can provide the service for them. Do not perform tasks which notaries are not allowed under the Notaries Act. Some common mistakes are preparing trust wills or preparing or witnessing family law documents. As new notaries, we will need to be extra vigilant in only taking on clients or matters where our competency has been proven. We must learn to say no, even when the rent is due. Number 5, duty to preserve client's property. The member needs to account to each client all money or other property received on behalf of that person. Number 6, confidential information. Members must hold client information in the strictest of confidence. Do not divulge any information unless expressly or by implication authorized by the client, or if required to do so by law. A mentoring example. I happened to be present during a phone call which tested the confidentiality of my mentor, Christy Martin, with her client. The call was from a woman claiming to be the named attorney for her mother in a POA document. The attorney claimed that her mother was capable, but she, the attorney, would be dealing with an upcoming real estate deal. She was looking for information on the file over the phone. Christy showed extreme patience in explaining her client's privacy rights and the law. Christy explained her dilemma to the caller that she would need to see the original document and the attorney's ID. Also, she was required to get express permission from the adult named in the document that the attorney could act and receive information, especially since the presumed attorney had indicated that the adult was capable. The result was that Christy maintained her ethical and legal responsibilities surrounding privacy and confidentiality while remaining calm and professional to an increasingly irate caller. Number 7, conflict of interest. In general, activities which could be expected to give rise to a conflict of interest with a client should be avoided. For example, acting for both sides of conveyance unless adequate notice has been made to all parties and they agree in writing. This scenario is not common in the more heavily populated communities of our province, but does occur in rural communities where there is less access to notaries and lawyers. Fees and disbursements. Members are entitled to reasonable compensation for services, and those fees require transparency and prohibit hidden financial benefit. Number 9, responsibilities to other practitioners. Conduct towards fellow members and other professionals should be courteous and made in good faith. Number 10, undertakings. Without question, a member should honor any undertakings that we give, any trust we accept, or any trust check we authorize. 11, duty to the notarial profession. Protect the honor, integrity, and reputation of our profession. And number 12, practice by unauthorized persons. As members of the Notary Society, it is our duty to assist in preventing the unauthorized preparation of wills for a fee or conveyancing of property by anyone who is not a notary or lawyer. This includes former members under suspension or membership that has been revoked. Number 13, advertising or marketing. Members cannot use any advertising or marketing techniques that could be damaging or unethical or could undermine the reputation, honor, or integrity of the notarial profession. In conclusion, honor, integrity, leading by example, and doing our best practice for the public is our mandate and goal for upholding the ethics of what it means to be a notary in BC. And as a side note, this part of the presentation will be what will be tested on in the Notarial Procedures 1 of the statutory exams.
Hello, I'm going to discuss what administrative law is, what tribunals do, the principles guiding them, and what happens if a tribunal breaches those principles. So what is administrative law? Administrative law is essentially the full array of rules that regulate administrative bodies. In a truncated version of the definition taken from Black's Law Dictionary, it can be divided into 3 areas: the statutes that give agencies their power, the body of agency-made law including relevant rules, regulations, and finding of fact, etc., and lastly, the legal principles governing the agents when there's a conflict with rights. The government delegates authority to administrative bodies as a matter of practicality. According to Justice Beverly McLaughlin, literally thousands of administrative systems occupy today's legal landscape, leaving these bodies or tribunals to make what must be tens of thousands of decisions each year in Canada. I had the pleasure of interviewing Margaret Hall, and while I can't share all of that interview, I have added some useful clips. Here's the first.
So I'm going to start by thinking about the different areas of administrative law that I think would relate to notary practice.
Okay.
So the first one, of course, would be those bodies that are created by the Notary Societies Act. And so you'll remember back from that administrative law class that those kinds of bodies, administrative law bodies, have to be created by a statute. So we always have to look in the statute to see where the authority is for their creation, and then the statute will also set out what they can do and the limits of their authority and the way that they can exercise that authority. So for notaries, that's where we're going to look, is Notary Society Act. And one of the bodies that's created that will be important for you to know about is the disciplinary body, the disciplinary committee.
Okay, so when a complaint is raised about a member of a government agency or professional association, a panel from within that group will hear the inquiry, similar to a court. The Society of Notaries is provided with the authority to create and regulate their own discipline committee by the Notaries Act, Section 26 to 41. There are actually a number of tribunals or committees that may impact notarial practice, though, including but not limited to the Notary's Own Discipline Committee and the Human Rights Tribunal. It's very important to get to know the Human Rights Code, which sets out the obligations for the private sphere, such as regulations regarding discrimination, which are too extensive to list here. As notaries working with the public and potentially employers of staff, we need to be aware of what our obligations are. We don't want even an accidental breach. An example of a Human Rights Tribunal and Notary Discipline Committee interacting can be found in the case of Fossum versus Society of Notaries, where Fossum raised a discrimination complaint to the Human Rights Tribunal concerning the form of discipline the society selected for his alcoholism. The society had made him make a solemn promise that he would not relapse, a promise which is of very serious nature for the notaries, attaching a high degree of moral blameworthiness for a breach. The court found that it was an indignity for Mr. Fossum to have to promise not to relapse his disability, and he was awarded $5,000. I've added links for the Human Rights Act and the list of tribunals in BC for you to peruse later if you're inclined. So as we can see, we have these tribunals and committees being delegated all of this authority and interacting with each other, all of which can have a potentially enormous impact on the rights of individuals. How can we be assured that the administrative bodies behave towards the public with the same standard, or members of their own society, with the same standard that would be expected by the courts? In Fossum versus the Society of Notaries, Ms. Morin mentions her role in the inquiry board was akin to that of a prosecutor acting on behalf of the society. But what ensures the committee remains within the scope of authority and upholds the same principles of fairness a prosecutor would? Margaret Hall provides some insight.
So administrative law is a relatively new area of law. Because remember, when we talk about administrative law, we're talking about these bodies that are created by statutes and the things that they do. And the idea at the root of administrative law is that when these bodies do these things, they should be bound by certain principles. The same kinds of principles that, sometimes we refer to as natural justice, principles of natural fairness. They're very similar in many respects to those principles of fundamental justice that we see in other areas of the law. So that's kind of the origin of administrative law. And so the question kind of arose, well, where do these principles that are supposed to govern how these bodies do things, where do they come from? Because they don't come from a statute. What's their origin? And so those early cases that talk about administrative law talk about those principles in terms of natural law. There's these natural principles of fairness and justice that are kind of just deeply embedded in our legal system generally. So they're, very similar to, they're kind of a part with, or of a piece with, the principles that infuse our legal system generally. So that's kind of the origin of all of these, now well-established theories of administrative law, which really means the way in which these bodies have to function. So they have to function in a way that's consistent with the principles of natural fairness and justice.
So common law imposes an obligation on administrative bodies, like a court, to follow natural law principles. As we learned in class, the obligations imposed by natural justice are a duty to act fairly, to act in good faith, and to act impartially or without bias. These can entail other obligations. For example, to have a fair hearing, a person must be given notice to know that a complaint has been raised, and both sides should have a chance to speak. Here's a clip where Margaret further describes what's entailed by natural justice.
Well, when the disciplinary committee acts, it can't just do whatever it wants to. it has to behave in a way that is consistent with these sort of fundamental principles of natural fairness and justice that are really rooted in our system. So, requirements like, giving a person notice if accusation of some kind has been made against them, giving that person an opportunity to respond to that in a transparent way, ensuring that people know not only what the decision has been in their particular case, but also this requirement that people be given the reasons for why the body came to that particular decision. All those kinds of things apply in administrative law because they're all characteristics of this sort of fundamental natural justice and fairness. So the idea is natural justice and fairness requires these procedural safeguards.
So when we look to the Notary Society's obligation to follow these additional common law requirements, we can see their commitment directly from their own governing documents. The Society's own complaint process document states that they are bound to respect the principles of natural justice in the complaint process, which among other requirements means that members accused of unprofessional conduct must be given proper notice of the allegations, have a suitable opportunity to respond, and the right to have their case heard by a fair and impartial decision maker at a disciplinary inquiry. So what happens if an individual does not agree with the decision made at a disciplinary hearing? The Notaries Act states that if a former member feels that the directors have erred in a disciplinary action taken against the person, an appeal lies to the courts. This means the individual can apply for judicial review of the decision. This allows the courts a degree of supervision over administrative bodies. So if an administrative body goes rogue, say they make a decision that's outside of their jurisdiction, a judicial review can void the decision. In general, though, the courts tend to defer to the expertise of the administrative bodies. However, it will balance how much difference it's given to the administrative body based on a standard of review, that of reasonableness. According to Sood versus the Society of Notaries Public of BC, a decision is unreasonable if it lacks justification, transparency, and intelligibility, or fails to fall within the range of possible acceptable outcomes which are defensible with respect to the facts and the law. So to wrap it up, it's important to understand the ways which tribunals are creative, where they get their authority and obligations from, and what is in place to ensure they follow the legal principles that a court might. It's also very important that we understand our own obligations to the various tribunals within BC when we set out to practice as notaries. Thank you.
This portion addresses the maintenance of an ethical culture. We will look at formal systems used to maintain ethics, including the use of procedures and checklists. Subsequently, we will examine the modeling of ethics as well as the importance of employees and ways to incentivize ethical behavior. It is your office's shared assumptions, values, and beliefs that comprise your firm's ethical culture. Ethical culture may best be described as the way we do things around here. If your practice were a person, ethical culture would be your office's personality. The ethical choices you will make will pose a genuine dilemma. Resolving these dilemmas will greatly depend on the ethical culture of your office. The advantages of fostering your ethical culture are abundant. 1. People appreciate an organization that is ethical. When the Cooperative Bank adopted their refusal to have financial dealings with apartheid South Africa into their formal ethics program, their lending grew by $3.8 billion, despite rejecting over £1 billion that would have contravened their ethics policy. 2. It has been shown that employees favor earning less with an ethical firm than earning more with an unethical firm. Employees favoring to do this act as a built-in security system that thwarts employee misconduct, reducing costs and fines, litigation, and loss of reputation. But perhaps the most persuasive case for maintaining ethics is ethical companies are simply more profitable. In developing your ethical culture, it is valuable to understand the external and internal motivators that drive it. Unfortunately, most change comes from external motivators like a response to a scandal or a change in legislation or technology. Internal motivators for change arise from damage to your firm's reputation stemming from unethical practices or work overload. However, the biggest internal motivator for change is values, such as trust, transparency, and openness. The more explicitly you promote them, the greater the effect they will have in maintaining ethics in the office. Having a strong formal system and ethical culture have been proven to lessen instances of pressure to compromise standards and the observation of misconduct. The creation of your own formal system begins with writing your own office policy that espouses your core values. A policy should reflect shared ethical values such as integrity, transparency, and reliability. Put policies in your own words and define what words like integrity mean to you. This has the effect of clarifying the values that drive your practice as well as demonstrating a personal commitment to them. They provide guidance to everyday behavior as well as a framework with which employees can use in solving ethical dilemmas. Keep in mind, smaller and less elaborate policies are often more adaptable in addressing ethical concerns. Give employees the opportunity to ask questions to clarify their understanding and get them to confirm their understanding by signing off on it. Keep in mind, policies not backed by a means of complying with your values are just intentions. Ensuring compliance requires codes and rules. Think of codes and rules as the 10 Commandments. Codes are what translate policies into everyday actions that are ethical in an easy way for people to understand.
Did you ever encounter a situation of ethical dilemma where all decisions look equal and it was difficult to choose which is best? And my answer to that is all the time. All the time. And that's the difficult one. And again, that comes back to being a professional. I think for you as a notary, if it doesn't feel right, it's probably not right. And that's one of the ways that you can decide which one of these two choices that I have, if you're looking at two choices, is going to be the correct one. The other thing is, talk to a colleague about it. Talk to a colleague about it. I know some members may be reticent to contact the society and ask them because you might not want it coming back on you because of the governing body. I can understand that, but talk to a colleague about it. And you'll all have gone through the SFU program. You'll know some very smart professors and people. I know in the past they've always been available to do that. So I think that's always the best thing to do when you're faced with those situations. Number one, if it doesn't feel right, it's probably not right. So if you've got two choices in front of you and you're leaning one way and one's not feeling right, it's probably the other choice is probably the best one. And as I say, talk to a colleague about it.
Ethical decision-making will pose a true dilemma in which there is no clear answer. To deal with this, your own code of ethics by necessity must be broad and non-specific. This allows your code to act as a guidepost in ethical decision-making while still allowing independent action as to the most appropriate path. A code of conduct, in comparison, is a set of rules that explicitly states required and prohibited behavior, and upholding it should be made a condition of employment at your office. You and your staff will be continuously making decisions, and it will not be possible nor advisable to stand over their shoulder. An effective tool is an ethical filter for decision-making. They work from the premise that each decision is unique and forces people to contemplate the ramifications of each choice made. They are also useful in later justifying or defending your decisions. It is difficult to recognize ethical issues. Research confirms that we often believe we will conduct ourselves more ethically than we do. The onset of certain feelings is useful in warning that you are dealing with an ethical dilemma. Such feelings include discomfort or a general feeling of uneasiness, unreasonable delays in making choices, and guilt. The use of an ethical dilemma questionnaire that elicits these emotions can be useful in determining if you are dealing with a dilemma. It can include such things as, would I feel embarrassed if clients and family found out? Would I be upset if this was done to me? Would it upset me if I read about this type of conduct in a newspaper? An indispensable item in your formal system should be the checklist. They ensure compliance and thwart potential ethical issues. Any in-house checklist should be written in plain language. There should be one for every transaction type with a client to ensure consistency, and they should have redundancy built into them. If your checklist for a notarization requires that IDs be confirmed by the notary and one other person, have a spot where the secondary person confirms they have done this. Also, explicitly state who that person is to be and what is to be done if that person is not available. However, any checklist or procedure you introduce to sustain ethics will fail if you do not model the behavior you seek to instill. In a survey of over 10,000 employees, it was shown that the ethical behavior of people is directly influenced by you as a leader. When you take ethics seriously, instances of pressure to compromise, observation of misconduct, and failure to report misconduct drops considerably among employees. Your team members and the general public alike will take into account two elements when considering your ethics. The moral person element entails the ethical conduct of your personal life. The moral manager element is marked by visibly modeling ethical behavior, using a reward system to hold people to account, and regular open communication about the significance of ethics. Weakness in one will build distrust in the other. If you sell a car to someone with undisclosed problems, you run the risk of being perceived as a hypocrite, even if you conduct your practices affairs ethically. For ethical behavior to become customary, people will need to trust you in both elements. Without trust, employees are reluctant to broach ethical issues, fearing the possibility of job loss and hostility from coworkers. You must be mindful that a commitment to maintain ethics is a commitment to transparency. You are transparent only to the degree in which you provide access to relevant information to employees, accept responsibility for your actions, and make decisions openly. As a role model, you must set the ethical tone, even when deadlines prove excessive. Be aware of traps that undermine the messages you give to people. Needing to be liked and overlooking misconduct to keep people on your side or keep the peace gives the impression that you are weak and people may take advantage of you. Comparing you or your firm's ethical transgressions favorably to another firm's more unethical behavior gives the impression that what you are doing is comparatively better, so you continue doing the practice. When employees perceive that you are setting an example for ethical behavior by adequately spreading relevant information and keeping your promises and commitments, they are 10% more likely to be satisfied working for you than employees who do not believe you are doing this. Team members will act on your behalf, and the ethical decisions they make will directly reflect upon you. Therefore, hiring the right people is essential. First, build ethical questions into the interview process and ask if they have ever been confronted by an ethical dilemma and how they responded. You might consider using a group decision approach when hiring. This could entail circulating a resume for employee input or having a member of your team attend an interview. Other factors to consider when hiring are consulting former employers to discover unethical conduct, checking for legal training certificates, and formal ethics training courses. Making adherence to the Society's guidelines and rules a condition of employment lets people know their importance in guiding their actions. There are various techniques that you can use to affect your team's desire to be ethical. Giving employees a space to voice their own values and concerns gives people the confidence to raise concerns not completely addressed by yours or the society's rules and regulations. Using a minor issue discovered while carrying out a notarization can be an informal opportunity to point out mistakes and their solution in real time, and communicates to team members that they are free to do the same. Sharing stories during breaks about an ethical behavior any of you have encountered in the past and their outcomes creates a hospitable environment for raising ethical concerns. You can also include an ethical component to an employee's performance appraisal. This provides a perceptible link between pay and ethics. Leaders generally use two tools to uphold ethics. One is to tie a breach of a code of conduct directly to transparent and explicit consequences. The downside is it becomes less effective the more it is used, and people might be less likely to raise concerns or admit their own transgressions, leading to costly mistakes. Another tool is the use of incentives, such as factoring ethics into the promotion process and personal recognition. Note that in Deloitte's ethics survey, financial compensation ranks below management's behavior as factors in promoting an ethical workplace. Incentives to maintain ethics can be both tangible and intangible. Tangible incentives would include bonuses, raises, and gifts, while intangibles would include flexible hours for people's children, private notes of praise, or vocal praise at a gathering. There are typically 5 elements for a plan to incentivize ethical behavior. Rewards must be fair to both the person receiving it and to others, lest the person receiving it is resented by their peers. To thwart this, consider giving them by peer nomination. Rewards should be easily understood. It should be clear to the recipient and to others the exact reason they are receiving it. Rewards that are received promptly better reinforce the behavior you seek to instill. Finally, an employee should not assume that for a given action or behavior they will always receive a reward. The emphasis for incentives should focus on the means of achieving a goal, not just the goal. The best systems are holistic in the sense that they benefit a team member not only at the office, but at home by including things such as flexible hours and paid time off. Incentives also have the potential to increase unethical behavior. For example, incentives to find mistakes in your drafts of documents can lead to an intentional inclusion of these mistakes, while rewards based on the number of files completed might encourage oversight of appropriate checklists, procedures, and adherence to society rules. To gauge the effectiveness of your systems for maintaining ethics, you need a concise criteria for evaluating them. If your aim is to minimize misconduct, the outcomes must be palpable, like a drop in actual misconduct, or, as a corollary, an increase in reporting unethical behavior by your team. When measuring success, stick to a few key measurements. For example, how many times in a month are you involved in settling an ethical dilemma in the office? Has the number of reports of unethical conduct risen or fallen? Keeping track of such things makes monitoring progress visible. The evidence for having a formal ethics program is visible when you compare the percentage of Fortune 500 companies that use them compared to the US average. Remember, persuading people to do only that which does not break the law is merely creating a culture of compliance. Fostering a culture of ethics is more complex and will require you to devise and monitor a formal system. It will also demand a readiness to evolve your system in relation to cultural shifts and changes in the law. Regardless of the strategy you use to do this, if you are not demonstrating ethical behavior through your actions and words, you will be undermining your ethics program. Ultimately, maintaining an ethical standard is a case of monkey see, monkey do.
Under the Notaries Act of BC, the Society has a duty to protect the public interest and to regulate its members by establishing standards to adhere to, as well as processes for handling complaints from members of the public. Members that are accused of unprofessional conduct must be given proper notice of the allegations, provided with an opportunity to respond, and have the right to have the case heard at a disciplinary inquiry by a fair and impartial decision maker. Misunderstandings can often occur due to lack of communication or confusion. A good starting point for members of the public would be to first contact the notary if an issue arises. Oftentimes, these misunderstandings can be resolved this way. Another option is to call or write the Society's complaints manager and discuss the situation with them. Before filing a formal complaint, it is also important to understand the scope of the Notary Society's authority. The Society has no authority to regulate the fees a notary is charging, to offer legal advice, to insist on certain services to be provided, to intervene in court proceedings, to make a finding of negligence, to intervene in personal matters, or to pay compensation. Only courts can grant compensation. If a matter is not resolved through contacting the notary directly, a formal complaint may be filed with the Society. Complaints must be in writing and submitted by way of the online complaint form submitted electronically, by faxing the complaint form to the Society, or by writing a letter that is faxed or mailed to the Society. Complaint forms can be found online at www.notaries.bc.ca, or can be sent to you directly by calling the Society office. Supporting documents involved in the transaction are required to be sent as an attachment to the complaint, or otherwise could result in delays in handling the case. Once filed, the complaint is reviewed by the Executive Director, a position currently held by John Mayer, or by an appointed staff member, oftentimes the Secretary. It may be decided at this time that additional information is required, or that a sworn declaration is required. A decision is then made whether there is a basis for an investigation to be carried out. If no basis is found, the file is closed and all parties are notified. If the complaint is found to have some substance of misconduct, incompetence, negligence, or fraud, the Secretary will conduct a preliminary investigation. A copy of the complaint, along with a statutory declaration provided for from the complainant, will be mailed to the registered address of the notary, and the notary is awarded the opportunity to respond to the allegations made. The Society conducts the investigation by obtaining further information from the complainant, the notary, and any other parties that may be involved. The findings are then reviewed by a discipline committee. Per Section 26 of the Notaries Act, the discipline committee must be appointed by the directors from among their number and comprise of a panel of 3 or more members. It should also be noted that per Section 28 of the Notaries Act, if reason arises, a discipline committee may inquire into a member or former member's conduct, whether a complaint is made or not. Confidentiality is always maintained by the Society throughout the entire process, and only a finding of discipline is reported. The Society retains all files pertaining to the matter for a period of 3 years, after which time the material is destroyed. A discipline committee will then reach a conclusion based on the information provided. No further action is taken by the Society if there is no indication of wrongdoing, if the complaint is deemed to be unfounded or cannot be proven, or if the evidence fails to indicate a breach of the Society's Act, rules, or bylaws. If the review of the evidence does support the allegations, a charge is laid against the notary and a hearing is scheduled. Per Section 29, subsection 1 of the Notaries Act, a member must receive at least 7 days' notice of the hearing. Per Section 30 of the Act, The member may then appear personally at the hearing or with legal counsel. They may cross-examine any witnesses involved, and they may present evidence pertaining to the matter. If the member fails to appear for the hearing, the Discipline Committee may proceed without further notice per Section 31 of the Notaries Act. After the proceedings are concluded, the committee must submit a report of its findings to the directors, on receipt of which the directors may accept and adopt a finding of fact that is made by the committee. They may review the proceedings as well as the evidence. They may request further evidence, or they may refer the matter back to the committee for further inquiries that they deem needed. At the end of the inquiry, the directors must decide if the member committed any of the infractions or conducted themselves in a manner that is against the best interests of the public or the notarial profession. Per Section 35, subsection 2 of the Act, the directors may resolve by majority vote to exonerate the member and dismiss the complaint, or to find the member committed infractions or engaged in poor conduct. Action taken against the member could include a reprimand and fine of up to $5,000. They may suspend or terminate their membership to the society, or they may subject the member to conditions of their practice that they deem fit. In any case, the directors may also impose costs to the member. Per Section 37 of the Act, if a member has been convicted in court of an indictable offense, the directors may suspend or terminate membership without following the procedures that are outlined in Sections 26 to 36 of the Act. Under Section 38 of the Act, the Attorney General, the Society, or a person aggrieved may also petition the court to inquire into a member's alleged breaches of the Act, regulations, or rules, into a member's professional misconduct or alleged incompetence, or into allegations of negligence or fraud. If the court finds the member guilty of the allegations, they may then order to suspend or terminate their membership. Under Section 40 of the Act, the Secretary of the Notary Society must publish all cases of suspension or termination on the Society's website. They must then notify the Attorney General, the Registrar, the District Registrars of the Supreme Court, the Registrars of the Land Title Offices, and the members of the Society. Under Section 8.04 of the Rules of the Society, a member may apply to the Board of Directors for non-publication of the discipline reports. The member must be able to demonstrate evidence to establish that harm would reasonably arise with publication of the reports. Considerations taken into account by the Board of Directors are whether the reports would reveal confidential information of a third party, whether they would harm a third party, or unduly harm the member, while still considering the general effect that this has on a member's reputation. The board would consider if there was reason to believe that a third party may unreasonably make use of the publication for purposes other than education, deterrence, or transparency. And the board would also consider if non-publication may undermine the transparency and integrity of the discipline process. Under Section 41 of the Act, a member or former member may appeal a decision made by serving the directors with written notice of the appeal within 14 days of the decision or order complained of. An appeal lies with the court. The appeal is an entirely new hearing. The member or former member and the directors or their respective counsel are entitled to appear, present evidence, and be heard. The court may then affirm the decision that was made by the society and dismiss the appeal, or make another order as may seem just.
The proper operation of the business requires client confidence in the business. The client confidence largely depends on the integrity of the professionals. It is therefore crucial to show clients that they can have confidence in the notaries because there exist rigorous standards of practice that are applied and respected by the society members. The disciplinary process and the rules of the ethics do not merely target extreme cases of fraud and dishonesty. There are also intended to foster proper and exemplary conduct. Thus, acting with integrity, loyalty, and competence, and in the interest of the client, understanding the products being offered, and offering advice and products that suit a client's situation are ethical obligations that are not satisfied by merely filling out the forms.